about the USA? Do you know about the government? Can you tell me about the Constitution?
I'm going to try to do some Supreme Court cases with you guys, all right? Supreme Court, definitely on the exam. We can cover constitutional ideas of judicial review and see if we can get through, I don't know, like 9, 8, 7, 10 cases. As many as we can without overloading you and me talking too fast for anybody to understand. Number 1, the only thing in the Constitution, in Article 3 about judicial power, or the Supreme Court, is there will be a judicial branch, there will be a Supreme Court, the President will pick the judges, the Senate approves them. Something else. Lifetime terms. So let's go over that really quick. Number 1, make sure you know it's the President's job to pick federal judges, appeal court judges, Supreme Court justice on the federal side of federalism. He doesn't pick state court judges, but definitely federal court judges, and the Supreme Court being the big one. Through the Judiciary Act of 1789, Congress created the number 9. 9 Supreme Court justices. And those 9 justices' job was to basically review the law. But the Constitution doesn't go into saying what's their power to do so, and what happens if they find something wrong. So, I'm forgetting to make sure you know. The Senate approves the justices. In class, we said if the President picks Brad Pitt to be on the Supreme Court, I want someone to say no. Or if the President picks Lucifer, the great leader of Satan and hell, I want someone to say no. So that's the Senate's job. In class, we call them the bow ties, and they're going to fix their bow ties and ask questions to Clarence Thomas or Robert Bork, or whoever the nominee is, and then they're going to pass judgment. So that's important to know. Another concept is lifetime terms. Lifetime job. I mean, we talk about term limits, and Congress and the House has 2 years, the Senate gets 6 years, the President gets 4 years, only 2 terms. So there is this concept that you shouldn't have a job for a long time. You should have to face the voters. You should have to go back and say, I'm accountable for my decisions. But the Supreme Court, once you're in, baby, you're in. I mean, unless you shoot someone at a 7-Eleven and get impeached, you're probably going to be a justice for as long as you want. So the question on the exam isn't, how many years do they serve? That's the 8th grade question. The 11th grade question is, why do they have lifetime appointments? And here's why. Their job is to review the law. In class, we do it like this. It's judicial review. And they're going to make up their own power, all right? That's your first court case. Remember it? Say it with me. Yeah. Marbury versus Madison established judicial review. And here's the concept. On one hand, I have a law or an action, something the President's done or hasn't done, or Congress has done or passed a law. On this side, I have the handy-dandy flip Constitution. I have the rules of the game. So if you think about it, the Supreme Court's like a referee. They look at the action, all right? The basketball player laid an elbow into the jumping opposer's face, and they look at the rule book. You're not supposed to do that, and they make a judgment that that was wrong. That's what the Supreme Court does. We just did Richard Nixon. They look at Nixon's action, they look at the Constitution, and they decide that action is unconstitutional, or that law is unconstitutional. That's an enormous power, and lots of people can argue about this in judicial interpretation and strict and loose. But at the end of the day, they pass judgment on the constitutionality of what our elected representatives decide. That can be a hard thing. Let's take something like in the 1950s. In the 1950s, there's a lot of racism. Jim Crow rules the South. And if you went up and you took a vote in the South, at least the people who voted, which were white people, and you said, how many are you for integration? Want blacks and whites to go to school together? 1, 2, 3. Oh, put his hand down. Do. It's very unpopular. Nobody wants to do that. Yet in Brown versus Board of Education, the court comes out and says, ha ha, you're going to do it. So why do they have lifetime terms? Because if they didn't have lifetime terms, what would happen to them? They'd be out. They get booted out by those the 98% of the people that were against them. Their job is not to win a popularity contest. Their job is to interpret the text of the Constitution. A hot button topic today is gay marriage. I'm going to be devil's advocate or not devil's advocate. I guess you shouldn't know. But if you take the gay marriage argument, it's pretty powerful. The 14th Amendment says, No state shall deny equal protection for its citizens. That was for African Americans originally, the Civil War idea. Mississippi, don't violate blacks' rights. But that's been used, for the police breaking in your house and search warrants. That's been used for the handicapped. That's been used for interracial marriage. That's been used for all kinds of groups. So gay Americans are like, over here, you're denying me marriage. And by doing that, there's benefits that come with marriage, societal recognition and tax cuts and, adoption laws and all kinds of things. So the Supreme Court, if they were to do that, they'd be unpopular. Less unpopular now than 10 years ago, but trust me, they wouldn't win a bed of roses with a lot of people. But they shouldn't have to worry about that. They should worry about what the Constitution says. So, some people will argue that's an activist course, making laws, making societal rules. But, without judicial review, we wouldn't have many of the things that we take for granted today, like our secure freedom of press or our rights when we interact with the police or all kinds of things. So just understand judicial review. I have 4 minutes. Wow. There are 2 kinds of cases. Cases that limit your rights, cases that expand your rights. You should know at least 2 for each of them. Let's do a couple cases that limit your rights. You'll notice most of these occur during times of crisis. That's the umbrella. One of them, you should know Dred Scott decision. Dred Scott decision, slaves are property. It's one of the causes of the Civil War, and it denied black people citizenship and really opened up the frontier to slavery. You should know Schenck versus United States. During World War I, Schenck was a protester, and he was telling people not to go to the draft, to avoid it, burn their cards, something like that. And he was arrested and charged with a crime. And he says freedom of speech. And the court says, no, you're not allowed to yell fire in a movie theater. And this idea is great for civil rights are limited in times of crisis. War crisis, Red Scare crisis, but Schenck got shanked. Another one would be Korematsu versus United States, World War II. Americans with Japanese blood, their rights are limited when the court allows for them to be put in internment camps in World War II. So there's 3 great limitation cases. You could also do Plessy versus Ferguson, and I'm sure there's lots that I'm missing, but those are some good ones. There's tons of expansive cases. So let's just really get to the heart of the matter and understand. You need to understand Brown versus Board, and I don't feel like lecturing on that on YouTube because I feel that you should know that. School integration, which leads to the president sending troops to the Little Rock Nine and getting school integration at the end of the gun. But that's the Supreme Court, and we've explained that a little bit. The big idea of expansion, and get this vocab down, is the Warren Court. In the 1960s, Earl Warren, who was a Republican, put in by Eisenhower, and this shows you, once you get a lifetime term, you can change your feathers. He was like, finally, I can say what I think, because he didn't have to face the electorate. And he's responsible for the greatest expansion of civil liberties, at least in some people's eyes, in the history of the court. Using the 14th Amendment, no state shall deny equal protection. It's called selective incorporation. He's going to slowly take some of the amendments and federalize them, nationalize them. Remember, the Bill of Rights is for the federal government, not the states. But what the 14th Amendment does is it kind of gives the feds the power to reach over and give that Bill of Rights to state citizens when they think they need it. So here are some cases that are on the test, or you should be able to write about. I'm going to be fast and furious, all right? Really direct. Engel versus Vitale took school prayer out. Schools can't make you pray. And that protects the 1% maybe, the Jew, the Muslim, the atheist, the witch, the Buddhist, against the 99% majority that have no problem with it. 14th Amendment, First Amendment. You have cases like Mapp versus Ohio. You all watch Law and Order. What happens when they don't wait for the warrant and they find the bloody knife? They can't use it. That's a court case that expands your liberty against police abuse. Miranda versus Arizona, the court case which makes the police read you your rights. You think they want to tell you you can be quiet? You have other cases like we've done New York Times versus United States. Sometimes on the test they have, boy, my brain is racing 1,000,000 miles an hour. Escobedo versus Illinois, where if you request a lawyer, that's the other one. Wow. Escobedo, where if you request an attorney and they don't give you one, then anything you could say could be thrown out. You have Gideon versus Wainwright, which gives you the right to an attorney. if you can't afford one. So there's lots of Warren cases that you have to get in there. In 10 seconds, make sure you know the early court was strong court. Remember, John Marshall's middle name is Schwarzenegger. These are 3 cases. Marbury versus Madison established judicial review. Get McCulloch versus Maryland, your national bank elastic supremacy clause. And Gibbons versus Ogden, interstate commerce. Wink, wink.